Welcome to the Commercial Awareness Compass. This is your weekly guide to developing commercial insight in a way that goes beyond just the news. Each week, we focus on one major news story and we break it down for you in a way that is easy to understand, going through the basic, intermediate, and advanced levels to help you in applications, upcoming interviews. I'm Tori, I'm a future trainee solicitor, and today I'm joined by Henry, a corporate lawyer and content creator. Today's session will be focusing on data privacy, specifically as concerns Apple and the UK. So as we go through the beginner, intermediate, and advanced levels, I encourage you to focus on how each explanation, how each level builds on the last. So we first focus on the basics, just understanding what's going on. And then we think about in the intermediate level, how businesses and industries are impacted. So why businesses care, why law firms care. And then in the advanced level, we're exploring strategic thinking. We're thinking long-term, big picture. So let's start off beginner level. Henry, can you please just explain the story to start off? What are we talking about today?
Yeah, for sure. As you briefly mentioned, we are talking about the secret order that the UK government has made to Apple under its Investigatory Powers Act 2016, whereby it effectively asked Apple, the UK government asked Apple to create a backdoor into its sort of iCloud services where it stores messages, photos, and other user data, which has ordinarily been protected by what Apple has as its advanced data protection feature. The UK government basically wanted access to that. Apple said, no, we are not doing that. So as a result, has withdrawn its advanced data protection feature. And that has caused some backlash and a number of concerns, which we are going to get into.
Thanks for that quick summary. I think what could be helpful as well at this beginner level is just to really understand what's going on, is thinking about this law. So you mentioned, is it the Investigatory Powers Act? Is that what it's called? Okay. So I thought maybe we could just talk through that a little bit, like specifically what are the powers that the government has under this act? What are the things that they asked Apple to do?
Yeah, for sure. So under the Investigatory Powers Act, the UK authorities, sort of the security services, GCHQ, government, etc., can effectively demand access to communications data. And the data they were after was the data that was end-to-end encrypted in Apple's iCloud services. In order to have access to this information, what the UK government needs to do is issue what is known as a notice. And there are three key types of notice that the government can issue. We have a data retention notice, where a company has to retain specific data. We have a technical capacity data, where it kind of forces companies to build access systems to the data that they hold, which is what we're seeing, or what we saw the government do in relation to Apple. And then we have a national security notice, whereby the government requires action to be taken for security reasons. So they're the three sort of key notices that can be made under this legislation.
Okay, thanks so much for explaining that, because I think it is just helpful. I don't know if many of our viewers will be familiar with the laws on data privacy and then also the government's power. So I think it's good background to have. I also wondered, so I think we'll get into this more in the intermediate level, but I thought for just a quick overview, for someone who's brand new to commercial awareness, so someone's tuning into this episode, they're like at the very beginning level. Could you explain just broadly why this story matters for commercial awareness?
Yeah, absolutely. And I think this is a really good example of not only we can see a huge data sort of privacy concern here, we can also see that this is going to be a bigger issue going forwards, given that the value so many companies are now placing on user data, and how the value in the sort of currency that data is being used in a sense. And whilst we can see that Apple have said, no, we're not going to offer this advanced data protection in the UK anymore, this then causes a number of issues, because not only do we have the individual users' data potentially at risk, we have conflicts then with privacy laws in other countries. We have the risk of other companies like Meta or WhatsApp or sort of other tech companies that are very data heavy kind of following suit or also facing similar legal challenges. So as more and more companies rely on data and as part of their services, I think this could potentially set a dangerous kind of precedent going forwards. But of course, kind of great for the lawyers because there's a lot of data work around this. There's going to be a lot of litigation, cross-jurisdictional work, which is obviously great for the law firms.
Yeah, thank you. That's a great overview. As just a quick anecdote as well, I'm glad that we're talking about this story today because when I was applying for training contracts and vacation schemes and I was asked on my applications to talk about a commercial story, I talked about a data protection issue actually related to Google. So I think there is lots of material to talk about. It relates to commercial awareness in many different ways. So I'm excited to explore it. I think we can move into the intermediate level then to go into a little bit more detail. At this intermediate level, I think there's kind of two general things to explore. So I think the first one is really kind of the commercial considerations for Apple. You know, what are the kinds of things that Apple is concerned with right now, both on the legal side of things, but then also just business wise? What are the types of things that Apple would be thinking about here?
Yeah, I think we've all seen that Apple is very much privacy focused in terms of tech companies. It's one of the ones that we are seeing are very much privacy focused, protect user data. So whilst they, of course, they're a company like any other company, they need to ensure that they're complying with relevant laws in relevant jurisdictions and so forth. By them creating this backdoor and allowing a government access to that information and foregoing the end-to-end encryption, they, from a reputational perspective, lose the kudos and sort of the goodwill that they've generated in that space. It also sets a dangerous precedent that if the government are asking them to do it, what else are they going to be asking for? But then that also needs to kind of keep in mind that on the flip side, which is what the government was arguing, that having this end-to-end encryption and not even Apple having access to the information being stored on sort of iCloud and photos and messages, the UK government has essentially said that this creates risk in a sense that child pornography, terrorism, and all of these sort of really inappropriate crimes are kind of being sort of not enabled, but information is being shared in that space and no one can really control it. So it's kind of a balance of where do you draw the line?
Yeah, so you have on the one hand the privacy concerns of protecting consumers, but then on the other hand, the government's concerns that they feel there's a legitimate reason sometimes where they would need access to users' data. So quite tricky. I see how you said as well that because this is such a complex issue, then that means that in a sense it's good for the lawyers because there's lots of work for lawyers to assist on, which was what I was thinking kind of is that second thing. So the first thing was what's Apple thinking about right now? And then the second thing I think, which is useful to think about at this intermediate level, is how would a law firm assist? What are the types of things that lawyers would be involved in here or more broadly as concerns data privacy?
Yeah, for sure. So in terms of the legal perspective, so we touched on in the beginning section the three types of notices that can be issued under the legislation in order to allow for this data to be shared or the government to have access. I think it's important to add that in this intermediate stage, whilst a notice has to be given, the notice alone isn't enough. There's basically kind of a double lock approval system to say, yes, this notice can be issued. And that's where we have governmental and judicial oversight to say yes and yes. And then only once we have both of those approvals, then the notice can be issued. And then in terms of, so of course, legal teams will need to assist in ensuring that notices are watertight, and the relevant sort of approvals are obtained. But conversely, you could then have law firms in this capacity saying the notice is not valid for X, Y, and Z reasons, challenging that, which I think we're seeing at the moment, that kind of going through. we'll need law firms to kind of advise firms on, or organizations, tech companies, on their compliance strategies to ensure that they are kind of complying with the relevant regulatory remits, that we see the monitoring shifts in any regulatory landscapes in the data field. And I think with AI, it's a hot topic right now in the legal profession, with that coming into the space as well, and the amount of data that is actually collecting and mining and going through, that's going to cause another kind of wave of data challenges and data points that firms need to kind of be assessing. And then also just generally advising firms and organizations on how to handle sensitive personal data and personal data to ensure that they are complying.
Yeah, so lots of different work. I think what's helpful to hear there as well, and I don't know if you wanted to say a bit more about this too. I felt like when I was at the very beginning of pursuing a career in law, I really only knew of the work that lawyers do in the contentious context of the type of litigation that they'd be involved in. But from what you just described, it sounds like there's a lot of non-contentious work as well. So I wondered if you wanted to just say a little bit more about that kind of contentious versus non-contentious work, that there seems to be quite a lot of different things for lawyers to assist on in this aspect.
Yeah, for sure. So let's take it in the context of data, because that's what this story is so heavily focused around. So the contentious parts would be kind of, as we mentioned in this particular story, challenging the legality of any notice, making sure that, if we say from an Apple and government basis, Apple may say, actually, the notice is not valid for X, Y, and Z reasons, or actually we're challenging this on a human rights perspective, or whatever perspective their legal teams are focused on, to invalidate what the UK government is saying. That's one way. Or equally, we could have individual challenge, where individuals are saying, no, I don't want my data being used in that way, or I don't want access to my data being given to X, Y, and Z, which, of course, an individual and a company bringing litigation against these companies is going to be a lot different. But then on a non-contentious basis, we have got the law firm advising on compliance strategy. We've got them carrying out the data protection risk assessments, the impact assessments, preparing risk assessments in terms of how data is being used, monitoring for shifts in data legislation, comparing the different regulatory remits. If we allow them access to this, does that mean we fall foul in this jurisdiction? What's the relationship with the UK, the EU, and the US in terms of how data kind of flows around those various jurisdictions? What happens in one country? Is it the same in another? And then if we take this story, if Apple says yes to the UK government saying, sure, have a backdoor access to all of our work, what then stops other countries saying, hey, hold on a minute, if the UK has it, we also want it? And then it won't just be Apple, it will be sort of Microsoft, Meta, and all of these other companies suddenly having all of these, I guess, access pathways into these data sort of online platforms, iCloud and the Microsoft Meta equivalents. What then happens to ensuring that our data that sits on iCloud is actually safe and cannot be exploited? Because if you've got iCloud and it's got all of these backdoors, well, you've basically just made a huge almost front door where like hackers and stuff can kind of get in and get our kind of information. So it's also about balancing that risk alongside then the, as we touched on in the beginning section, the reputational risks of the company like Apple saying we're a privacy first end-to-end encryption company. There's a lot of goodwill, a lot of their advertisements and their standing in their kind of kudos within the industry is that they're so focused on user privacy. That kind of falls away. And then I guess the value of the company and its products to an extent kind of fall with that. So that's more like the commercial side of the implications of kind of the non-contentious sides of the data points.
Yeah, thanks so much for explaining that. I see there's so many complex considerations, but what I think makes this story so great as well for our viewers to think about is because even though it's very complex at that high level, at the same time, I think almost everyone, probably everyone watching this video can relate in the sense that, you know, most of us, use social media or use these technologies. So at the beginning stage, we can understand the concerns around data privacy, and we can connect it to ourselves, but then see, of course, how it's a huge thing that affects, many, many different things. You said something that I think brings us on then to the advanced level, which is more looking at the big picture, thinking long term. I mean, you said a few things that I think can really connect to this advanced level, that if students were to bring that up in their interviews, they would be showing that very strong grasp of commercial awareness. The first thing you said was you talked about the kind of UK, EU, US relationship then, and how that creates some different issues of if there were to be different rules in the UK, or if that would affect any kind of data agreements that the UK has with other countries. Could you speak a bit more about that?
Yeah, for sure. And I think a lot of the firms that many of the viewers will be applying to will likely have sort of offices in other jurisdictions, or they'll be working with clients that also operate in other jurisdictions outside of the UK. But what we're seeing is that Apple is kind of arguing that forced compliance with the notice that the UK government is giving ultimately undermines sort of privacy rights under the relevant data protection legislation and the European Convention of Human Rights. So that has to be kind of balanced with the UK saying, well, if we can't have this, or if this is going to happen, then is that actually undermining the UK's sort of regime in terms of the data protection? Because whilst we've got the term GDPR is used quite a bit in terms of just legislation around data protection here in the UK and the EU, but the GDPR is obviously EU focused, and the UK has incorporated that by way of the Data Protection Act 2018. Because of Brexit, we're obviously not part of the EU anymore, but the EU has granted the UK what's known as an adequacy status. And this case is kind of highlighting that there's a potential risk that could the UK lose that status kind of off the back of this. And then I think across the globe, we could see that there are going to be potentially claims in other jurisdictions. Like, are we going to see similar in the US, putting pressure on Apple to create backdoors? Because the US notoriously has a lot more, I guess, they're a lot more demanding in terms of data that they want or their government wants access to, which is why there's quite, without going into too much sort of technical detail, the relationship between the UK and the US in terms of how data goes across in sort of the privacy shield regime was quite contentious at the time. So I think that is going to be a huge issue kind of off the back of this conversation.
Mm-hmm. And the other thing that you had said, which I think it does connect to this to an extent as well, is that it could potentially not only be Apple. You mentioned that then this could affect other companies as well. So would you say that that's something that lawyers, so let's say a firm which does not advise Apple but advises another one of these companies that you mentioned, do you think this is a story that they would be paying attention to?
Yeah, I think that the legal teams of, say, Google, Meta, and so forth would definitely be paying attention to this story, because it could set a precedent for how things kind of go forwards, and whether or not there are going to be any fines issued by, say, the UK government for sort of non-compliance, and so forth. And I think that is going to be, again, it's one of those stories that's one to watch. This is kind of happening now. Apple have just said, we're not complying. We are just going to pull the whole advanced data protection provisions, which prevent the end-to-end encryption, which is what the UK government wanted to kind of have a backdoor into. So I think as this case develops over time, over the next couple of months, we are going to see what the ramifications are, how that impacts Apple, how that then in turn impacts other companies. And then that's when we'll see their legal team saying, okay, Google, so this has happened to Apple. What are you doing in terms of data, your end-to-end encryption? Are there backdoors? Could the UK government send a notice to you? This is what Apple have done. This is what we kind of suggest you maybe do for the first couple of stages, but I think for sure they will be paying attention to this, and I would say that they are very silly if they're not doing so.
So really, yeah, they would need to be giving that kind of strategic, forward-thinking advice now, proactively.
100%.
I had one other question for you, and then I guess I would just open it up if there's anything else that you wanted to add. This question is a bit more general, but because so you were talking about data privacy, data protection, and then you said something about without getting too technical, which one, I mean, I appreciate. I think that you explain these things in such an accessible way to our viewers, which I'm sure they really appreciate as well. But I would just wanted to ask you how can our viewers get comfortable, get confident with talking about these more technical issues? How did you kind of develop the foundational understanding to talk about some of these things?
I would firstly say that when you go into your assessment centers in your interviews for vacation schemes and training contracts, you are not, and you should not be expected to be able to recite the relevant protocols within the GDPR, the adequacy status sort of regime, and how countries are determined to be adequate, and how the US Privacy Shield works in any detail. And because it's so vast, and I'm 6 years PQE, and a lot of it still confuses me. But I think what you can show is that this exists, that there is a relationship between the data transfer between the UK and the US. Just showing that it exists is a really good foundational level of just the fact that there are data privacy issues. Of course, we know that within the UK, but if I'm thinking with my commercial head and I'm applying to this international law firm, of course they work with companies in other countries, or their London headquartered country also has a LA based office. There's going to be a transfer of data. How does that work? And just saying that we're going to need to engage the teams from the US to give their perspective because they're qualified in the US data regime. I think that shows a really good experience and knowledge, and following these stories, getting to understand them on a deeper level, not just you've read the headlines. Follow the story. If this is one that really interests you, and I think, Tori, you mentioned earlier that you spoke around a data issue with Google in one of your interviews. Data is a really, really hot topic, and these cases are huge, like the Google one you spoke about, Tori, like this Apple one. These are kind of landmark sort of ongoing battles that you can follow, and you could watch this now and think, this is really exciting, but your interview isn't until June. There's going to be a lot that happens. So if you follow it, you can get really embedded. You can really kind of understand this story, how it's developed. And to me, I would be really impressed by somebody who doesn't obviously recount what's happened day by day, but can say, this story happened and this is what's been going on. This is how it's relevant. If I had to advise a client, this is what I would suggest just from my sort of readings. And this story, big stories like this, so many of the big firms will be writing papers on this. There will be articles, there will be posts around this. The firms that you're applying for, see what they're saying about this topic, see what their viewpoints are. How does that influence your thoughts? How does that influence what you think about this? Does it give you more to think about? Go away and look at that. Really kind of embed yourself into this story.
Thank you so much. I just want to draw an underline under what you just said about what like law firms' commentaries are on these issues. I think that is a very underrated tip, actually. Look at the law firm websites, see what they're saying, because I think oftentimes students are looking in their commercial awareness for specific deals or cases that firms have been involved in, which that is also worth looking at. But there's many that the firms won't have been involved in, but they will be commenting on, and then you can learn so much from that too. So thanks so much for pointing that out, Henry. Did you have anything else you wanted to add before we wrap up the session?
No, I just would echo what we've said, that this is a really interesting ongoing battle, and we're going to see lots of sort of landmark opinions, thoughts, and sort of actions come out of this. So I would say that this is a really hot topic to follow if you're interested in this space.
Yeah, absolutely. I echo that completely. As I said, having spoken about data protection issues in my applications too, that this is really worth following. So to our viewers, thank you so much for joining today. Thank you, Henry, so much for giving us your insights. Remember that commercial awareness is more than just staying on top of the news. As Henry said earlier, it's not just about seeing the headline. You really want to think about why these events matter to clients and how you, as a future lawyer, can provide strategic value and how you can impress in your training contract and vacation scheme interviews and applications. So whether you're at the beginning, intermediate, or advanced level, the key takeaway for you here is to approach each story with a curious analytical mindset. Always be asking, how does this impact clients? What would a law firm do to help? Why do businesses care? That's the mindset that will help you impress. So join us next week to keep building your commercial awareness. And until then, prepare without the panic.